Good afternoon. I'm Russell Robinson, the Distinguished Haas Chair in LGBT Equity and Professor of Law here at Berkeley Law. And we're honored to have so many fine speakers here today at the 2015 Berkeley Law Brennan Center Jorde Symposium. The symposium was created in 1996 to sponsor top scholarly discourse and writing from a variety of perspectives on issues that were central to the legacy of Justice William J. Brennan, Jr. The Brennan Center named the symposium in honor of its major benefactor, Thomas M. Jorde, former Brennan clerk and professor emeritus at Berkeley Law. The symposium typically presents the same lecture at two different sites, one in the fall and another in the spring, with a different pair of prominent commentators at each site. The fall lecture is typically held at Berkeley Law, and the other lecture is held at a different law school. It rotates every year. The spring lecture is at a different law school every year. I said that. Both lectures and the four commentaries are published annually in the California Law Review. This year we have the very special pleasure of hearing from Associate Justice Stephen G. Breyer. This year's lecture is entitled The Court and the World, the Supreme Court's New Transnational Role, based on Justice Breyer's new book. It's been getting great reviews all over the place, including the New York Times. He will argue for the many ways in which American judges, when interpreting American law, should take greater account of foreign events, law, and practices. We will also hear briefly from Judge Charles Breyer, a Bolt alum, and a senior judge of the U.S. District Court for the Northern District of California. And we'll have commentary on Justice Breyer's lecture by Dean Sujit Choudhry and Professor Jenny Martinez of Stanford Law School, that other law school in the Bay Area. So let me just say a few words about the presenters, but you have their bios in the program. So Justice Stephen Breyer is a graduate of Stanford, Oxford, and Harvard Law School. He taught for many years as a professor at Harvard Law School and the Kennedy School of Government. Justice Breyer was appointed a Supreme Court justice by President Clinton in 1994. He has written books and articles about administrative law, economic regulation, and interpreting the Constitution, among other things. And it's really astounding as a professor who tries to write, it's amazing that he is so productive while deciding Supreme Court cases. I had the honor of clerking for Justice Breyer during the 2000 term. During that year, it seemed as if we were perpetually in dissent, most famously in Bush versus Gore. However, a lot has changed in the last 15 years, and it's been a pleasure to sort of watch the change. So according to the New York Times, during the most recent term, Justice Breyer voted in the majority more than any other justice. And he wrote a series of important and sometimes surprising opinions. So for example, he wrote the court's opinion holding that a state may refuse to issue license plates bearing the Confederate flag. And he persuaded Justice Thomas, of all people, to be the fifth vote in that case. In addition to playing an influential role at the heart of the court, Justice Breyer took bold positions in cases such as Glossop versus Gross, where his 40-page dissent concluded that it is highly likely that the death penalty violates the Eighth Amendment. Judge Charles Breyer, Justice Breyer's brother, was nominated by President Bill Clinton to a seat on the United States District Court for the Northern District of California in 1997. Judge Breyer was assistant special prosecutor on the Watergate Special Prosecution Force and spent many years in private practice. Jenny S. Martinez is the Associate Dean for Curriculum, Professor of Law, and Warren Christopher Professor in the Practice of International Law and Diplomacy for Stanford Law School. Professor Martinez clerked for Justice Breyer and is a graduate of Harvard Law School. We worked side by side years ago on the Harvard Law Review. Sujit Choudhry is the Dean and I, Michael Heyman Professor for Berkeley Law. Prior to coming to Berkeley Law, Dean Choudhry was Cecilia Getz Professor of Law at NYU School of Law. In 2010, he was one of just 4 Canadians to receive the Trudeau Award, the Canadian equivalent of the MacArthur, that would be the Genius Awards. So I hope you will enjoy the presentations today. Join us at the reception afterwards, and we will now hear from Judge Charles Breyer. Thank you.
Thank you very much. You know, when they ask a member of the family to introduce the principal speaker, that's always a little dangerous for the principal speaker. I do want to point out, and I don't want to detract from my brother's accomplishments, that Stanford Law School was my backup law school. So I appreciated that. The question I think I'm most frequently asked because of my relationship was, well, your brother, he's a moderate, or he's a conservative, or on certain issues he's the liberal. How would you characterize it? And the interesting thing is that those terms mean nothing to me in terms of my brother. One term does actually mean something to me, and that is he's a pragmatist. He's a person who looks at a legal problem and tries to figure out what is a practical solution to that problem in the context of what the Constitution says, and I think, as you will hear this afternoon, what other jurisdictions, other courts, other practices, other customs from other countries say about the law. So I think that on the plus side, you're going to find out when he discusses things such as the civil liberties in the time of national security crisis, or the Alien Tort Statute, how it opens the courts of the United States to redress for occurrences that occurred outside the United States. And such mundane subjects as copyright, antitrust, and even discovery, how that all plays a role in looking at its implications with respect to foreign jurisdictions, foreign places. I should add a word of caution that my brother not only wrote this book and has lived the life of a Supreme Court justice, he also is responsible for airline deregulation and the sentencing commissions. With that, Justice Breyer.
Thank you. That was a very nice introduction. I mean, then it got sort of weak at the end. But I didn't know what he was going to say. It's the most stirring thing in his mind was, what does he think of when he thinks of me? I'm only 3 years older, and we used to drive places in the summer and together in the car, and he might have said, but I think of him, I think of a real pest. And that's possible. My finest hour under the age of 15 was when he was singing a song over and over. I'm sure that's no experience for you. You don't know younger brothers perhaps singing this really irritating song over and over in a way that only irritates their older brothers because their parents don't understand why, and the other two do. And I said, I'll give you anything if you can keep quiet for an hour. And he did. I never thought he'd do it. And my mother made me give him my bicycle. It was terrible. But I got it back. I traded him my place at the table for the bicycle. It's true. Then he brings up airline deregulations, working fine. So the sentencing guidelines, I know most judges feel a little bit like cholera. I was in October 1987, I was trying to explain the guidelines to some judges in the 11th Circuit. I remember October 87, most of you won't know, but some of us do. There was a huge dip in the stock market, a real collapse. And I was sitting next to Judge Hill, nice judge, very nice, and he was trying to make conversation. And he said, well, what did you do before you became a judge? I said, I worked for Senator Kennedy. On what? Well, airline dereg, et cetera. And he said, oh, you're responsible for airline deregulation, are you? I said, well, maybe. And he said, now you've written these sentencing guidelines, have you? I said, no. He says, they didn't just put you in charge of the stock market, did they? He said, but there we are. It's very nice for me to see Russ and Jenny and my former clerks who have become professors. Absolutely terrific. And thank you for the introductions. I appreciate them. This book, what's it about? Why did I write it? Stop me before I strike again. But I think it's best described, which I heard someone say, it was a good student of literature. He said, if you've read, and you should if you haven't, it's a great book, The Charterhouse of Parma. And the hero of The Charterhouse of Parma is a soldier at the beginning, wandering along the battlefield of Waterloo. And he's thinking this to himself. He sees the smoke and the artillery and the guns are going off and horses are running every which way and it's real chaos. And he thinks to himself, something very important is going on here. I wish I knew what it was. Is that? So when I hear the words interdependent, globalization, shrinking world, well, I think they range between a cliche on the one hand and a sort of buzzword on the other that can't quite get it concrete. So I thought it might be helpful to write very concretely what do these words mean in the terms of a life of a Supreme Court justice? What has it done in the court? And there, if I look back 20 years and now to today, I think we have many more cases where those words concretely make a big difference. And so I've listed 4 or 5 categories and discussed them in an effort to try to focus on what the problems are that they raise now. And I can give you a few examples. I will say what they are about. One of them, which is of interest to people, is a traditional problem that goes back thousands of years. Problem: there are security needs. In our context, the Constitution delegates the security authority almost entirely to the President and to the Congress, not to judges. Well, what happens when security conflicts with civil liberties? Because the Constitution delegates significant power in that area to the judges. So what are judges supposed to do when they conflict? Well, if we go back 2,000 years, we can find a phrase that governed for many, many, many centuries mostly what most judges did, and that's Cicero. I was just at my high school reunion. I found a woman there, she said, we had Latin for 4 years. We did. I said, I don't remember a word of it. Nor did she, actually, but she didn't admit it. But the point is, Cicero said, and I translated it like this, when the cannons roar, the laws fall silent. I used to translate it that way, until somebody pointed out to me, you know, the Romans didn't have cannons. You must really know nothing about it. So that was a little awkward. So then I thought what I would say is, you get the point. In time of war, no law. No courts, anyway. Stay out of it. And if you look at American history, you get the idea that that was the rule that was followed for quite a long time. We can understand it sometimes. Lincoln, during the Civil War, tens of thousands of people were put in prison. You say, well, perhaps necessary. But Secretary Seward called in the British ambassador one day and said, I can push this bell and have anyone I want in New York thrown into prison. I can push it twice and have anyone in Ohio put in prison. Tell me, does the Queen of England have such power? Now, the court did get involved, but only after the war was over. It tried at the very beginning, got nowhere, but after the war was over. And then if we look forward, jumping in our history course, very quickly, and look at World War I, it wasn't very different. I mean, we had learned hand dissenting sometimes, and Holmes and Brandeis sometimes writing great dissents. But basically, there were all kinds of written materials censored and lots of people put in prison. And if I characterize it, I think it's fair. Others have characterized it this way. The courts did virtually nothing. And that continued. It continued through the Great War of the Chaco, which no one knows about. It was Bolivia, I think, Paraguay, over some oil, which didn't exist. And the Curtiss Wright Corporation was sending them arms. And President Roosevelt wanted to stop it, so we got Congress to pass a law saying the president can basically make anything he wants a crime in this area. What? This was a court, by the way, that was telling him he couldn't do anything. Yet it let him do that. Why? Foreign affairs, security, or jump to World War II. And we have Korematsu. Korematsu, where 70,000 Americans of Japanese origin, American citizens, were taken from their homes right here. Tanforan Racetrack. That still exists, doesn't it? It's a shopping mall? I am indeed shocked. It used to be a racetrack and people enjoyed it. But nonetheless, I promise you those internees didn't enjoy it because they were sent from their homes to Tanforan in Northern California and Santa Anita in Southern California, and from there to camps, which were really prison camps. And they spent the war there. For what reason? By 1944, the case got to the court of Korematsu, which questioned that. I met Fred Korematsu. He was a great guy, actually. His parents did not want him to bring that case, but he was a very feisty guy. I knew him because our next-door neighbor in Cambridge was the daughter of a man named Ernie Besig. Ernie Besig had represented him. Ernie Besig was the ACLU lawyer at that time, representing Korematsu, and the ACLU wouldn't sign the brief. They got into it later. But she called me over because Ernie Besig and my father used to play poker together in San Francisco. That was at a time when you could drive from house to house in less than half an hour. Feisty guy. He was certain he was going to win. And so was Besig, because by 1944, everyone knew there is no reason any longer to keep 70,000 Japanese in camps. No reason. And anyone who looked into it would have learned pretty quickly there was never any reason. Never. That's what J. Edgar Hoover told President Roosevelt. Don't do it. And one of the big advocates for it was Earl Warren, who said it was the worst thing he ever did, or certainly one of the worst. But in any case, there they were, in prison, and the Supreme Court wrote an opinion and said, stay there. Now, I've thought a lot about that case, which is generally recognized as one of the worst cases that the court has written. But I thought, well, why did they do it? The people who wrote this, you know, it was Black and Douglas and Frankfurter. These people were civil libertarians. They were the ones behind Brown. I mean, why did they do it? And the only explanation that I've come up with is, well, they were thinking, somebody has to run this war. Roosevelt or us? And we can't. And therefore Roosevelt. Well, after a while, by the time of Korea, a somewhat different court, not totally, I think began to think that this is not such a great idea, Cicero, or things that look like Cicero. And they held, almost for the first time, that the president, even at the time of the Korean War, who had seized the steel mills because he wanted to avert a strike that might have threatened lives of American soldiers in Korea, they held he couldn't do it. Now, you'll read about that case undoubtedly, but it's always taught because he had a tripartite categorization of presidential action. I didn't read it for that purpose. I read it to try to figure out what was Jackson, what's moving him. And I think what was moving him, it's just my guess, what was moving him was he had seen, and the court had seen, what had happened in Europe. And the court had seen what had happened when you give one person too much power. And they didn't say anything rude about Truman or about Roosevelt. But sometimes I think they're deciding this case against Roosevelt. And Truman is their objective. That's because he's there now, and less popular. But in any case, they say no. And you say, well, let's look to the precedent. That's his famous line, a famous line. Look to the precedent. Look to what the founders thought. And Jackson wrote, he was a beautiful writer, beautiful. He wrote, when you ask what the founders thought about the presidential power in these circumstances, or the precedent, he said, it's like asking Joseph to interpret the dreams of Pharaoh. Now come up to Guantanamo, where in Guantanamo we have four cases, each brought by a detainee. Not popular, the detainees. One of them was bin Laden's driver. He's not the most popular person in the United States. They all are suing the Secretary of Defense, the Defense Department, the President, powerful people, all for one. The issues tended to be whether they could get into court. At one instance, Congress passed a statute that said no habeas corpus. The court held that was unconstitutional. So they got into court. Some have been released, some are still there. But the victory, legally, was for the detainee. And the theme, if I try to characterize it, I don't know if others would do the same, is Sandra O'Connor's statement in one of these cases. The Constitution does not write a blank check to the president to do what he wants about civil liberties, not even in wartime, time of national security emergency or threat. And I signed right on. No, it's a good statement. It says we're not going back to Korematsu, that Cicero is gone. We've thought a long time gone. Goodbye, back to Rome, even if they don't have cannons. But now, as I've given you enough time to think about it, the thought may have crossed your mind, if the Constitution does not write a blank check, what kind of a check does it write? Look through the opinion to see what that says about it. Nothing. I'll be honest with you, virtually nothing. And I say, why doesn't it say something? And I'll say, because we don't know. That's why. Because in fact, there are many different situations. Beware of going too fast, too quickly, of going too far, too fast. Beware of that. All right, fine. Now we have not a solution, we have a problem. And the problem is one that, at least in my view, could extend quite a long time, with all kinds of threats that come from all kinds of different places in the world. And all I will say, since I end this really with instead of a glorious suggestion, I just have an inglorious question. How do we answer this kind of question without knowing something about the security problems? How do we answer this kind of question without knowing something of what's going on in respect to security, likely beyond our borders? And isn't it likely to be helpful in answering these kinds of questions, which I suspect we surely will have, to know something about how other countries with similar problems deal with it, not because the other countries are right, they may or may not be, but because knowledge of different methods of going about similar problems might help us reach a correct solution. If there is no blank check, it might help us to fill it in a little better. Well, I go on at this at some length, but I'll stop right here because I want to give you a totally different example. You see the kind of example? So that's an important question. And more are coming up. Let's try commerce. That's pretty obvious. Commerce is international. We have in front of us the man from Thailand, Supap Kirtsang, student, Cornell, and he gets to Cornell and on a scholarship, and he discovers that the books in Thailand are the very same books, are much cheaper. So he writes home and asks his family to send him some, and they send him a few copies. Actually, they sent him quite a few more than a few copies. And he thought it was a very nice idea to sell them to others, which he did, and began to make a nice profit. And the publishing company, thought that was a bad idea and brought a lawsuit. Now, whether he can do that or not, or whether it's stopped by something called the first sale doctrine or permitted by the first sale doctrine, that is a really technical copyright question. Really technical, and it's in there in the statute. I mean, it is, I promise, technical. So I get the briefs in my office. Briefs, that's what we read. They're not brief. I don't know why they're called brief. But regardless, we have a stack like this. And there are briefs there from lawyers all over the world, from Asia, from Europe, businesses all over the place. And I could not figure out why, in this case, there are so many briefs from so many different people, until I read a brief that said, you realize, I hope, that copyright today is not just a question of books or film or music. Go buy a car. The car has software. The software has copyrights. Or go into a store, whichever one you want, and look at those products. They have labels. Many of those labels are copyrighted, and quite a few come from overseas. So we are told by one brief that this case will affect $3 trillion worth of commerce. Now, even today, that's a lot of money. $3 trillion. And that's why all those briefs are there. And there is no way, in my opinion, you can make up your own mind reading the opinions, but in my way, there's no way to resolve that case satisfactorily without knowing something about the copyright laws and how they work in other countries and what the publishers are trying to do. Are they trying to divide markets? And something about the other industries, and that's going to take us well beyond our shores. Or take an antitrust case. Man from Ecuador, plaintiff, sues defendant, Dutch. What does he do? He's a distributor in Ecuador of vitamins produced by a cartel, one member of which is Dutch and they're mostly European, but there is an American, and he sues in New York. Now, why did he sue in New York? Maybe because if they were so expensive, this cartel raised all the prices, he was too weak to get to Europe. Possible. Another possible reason, treble damages. Treble damages and attorney's fees. Can he or not? We have to interpret again some words that are pretty obscure. Very obscure. And we are given briefs by the European Union Authority, Antitrust Authority, enforcers all over the world who are trying basically to enforce slightly different but basically similar anti-cartel, anti-price fixing laws, and there is no way to resolve the correct interpretation of this American statute without knowing how they work so that we can reach an interpretation that allows those different enforcers to work together harmoniously and doesn't create chaos. Same is true of securities regulation in a case called Morrison. I mean, Australia has their enforcers, so do we, and so do most countries, all aiming at the same thing now. Very different from when Judge Friendly wrote. And how do we, in fact, get these to work together harmoniously? Or if you want a different area, try Dolly Phil Artiga. Dolly Phil Artiga, here in the 70s, from Paraguay. In New York, she sees the man from Paraguay who tortured her brother to death, working for the dictator Stroessner. And she finds a law passed nearly 200 years ago that says an alien can bring a suit for a violation of the law of nations and recover damages. And she did, and she did. She won. And she went back to Paraguay. She said, I came to the United States to look the torturer in the eye, and I came away with so much more. But that statute then began to grow in terms of use. And more people found that they could fit their case into that statute because there are human rights abuses throughout the world. And then the question begins to arise more and more, well, how should it be interpreted? Who are today's pirates? More than that. What happens if an interpretation creates interference with the laws of other countries? South Africa files a brief and says, we are dealing with apartheid, its victims, and its perpetrators. We have truth and reconciliation, that's our method, and we do not want federal judges in New York or any other place in the United States interfering one way or the other. And how do we interpret it to take that into account? And how do we interpret it so this law, which seems like a pretty good idea, works out uniformly, or roughly uniformly, and doesn't keep getting in each other's way and causing infinite trouble in many countries of the world, which may have somewhat similar or not quite similar or possibly similar laws? That's the kind of question in front of us. Human rights area. Or domestic relations. Domestic relations, there you'll say, there is a system of domestic relations law in the United States. Indeed, there is. And they're called state judges, and they know how to do their business. And those who are domestic relations judges, which is about the toughest job in the federal system, it's not in the federal system, it's in the state system. It's the toughest job of a judge. Judge Eddie Ginsburg, my friend up in Cambridge, domestic relations judge, used to tell the couple that's fighting, I hope you can reach an agreement, because whatever you reach together is likely to be much better than whatever I'm forced to impose. And suddenly, we, federal judges, in the Supreme Court have in front of us 3 cases over a course of 3 years interpreting domestic relations treaties involving abduction of a child, where we have groups on one side that are working their lives against abductions, and they say interpret it this way, and on the other side, groups that are worried about spousal abuse, which is a reason why there is sometimes an abduction. And they're each arguing at cross purposes. And why are we to decide something like that, we who know so little about it? And the answer is because it's in a treaty. But why is it in a treaty? It's in a treaty because today more and more and more and more marriages cross international boundaries. That's why. And they better watch what we do, the people who write those treaties, to see if it's correct and amend the treaty if it isn't. Now, do you see the kinds of problems? And I ask sometimes, I ask an audience, I might as well, why not ask you? I'll ask you. How many organizations do you think there are? I mean, treaties and executive agreements very often set up little bureaucracies to work under the treaty, like the International Trade Organization, World Trade Organization. See, big administrators. And they make rules. And those rules, in practice, bind more than one nation. How many such organizations would you think there are? How many think there are more than 50? How many think there are more than 100? 500? 1,000? 2,000? No, it's much more than 2,000. And we belong to several hundred of them. And you've heard of some, of course, the World Trade Organization, and others perhaps you haven't, the International Olive Oil Commission. But nonetheless, they're all over the place. The bluefin tuna, the greenhouse gases, the United Nations. I mean, they are all over the place. And our regulators in the securities area regularly go off to Bali. And in Bali, there's a meeting of bankers and regulators. And they sit down and try to figure out what to do. Then they come back. And maybe in the SEC they then do it, but the real decision, we're told, is over there. Yeah. What kind of rules are going to govern that in the future? I don't know. But I do know that if Congress doesn't have the power to delegate some of these things to work. To ICON, what about ICON? Everybody knows about ICON. ICON governs everything in your lives. It runs all the rules for the internet. And by the way, ICON is a private organization down in Los Angeles. What about their rules? Now, do you see the kinds of problems? And all I can say is a trivial thing. I can say a cliche. I can say if Congress doesn't have any power to let other groups, just like the ones I've been talking about, set rules, how in heaven's names can we solve the problems that are facing us, such as environment, such as security, such as health, such as dozens of things, that the problem crosses more than one border. But if there are no limits at all, what about fairness? I was an ad law professor. Russ knows that. There's the Administrative Procedures Act. It has certain fairness in it. What about delegation? I mean, what happens to Article 1 if all the power goes to the administrator of the International Olive Oil Commission? Well, I'm sure neither of those answers is going to be correct, and so what is? And that's, of course, my object. I want to go through area after area and simply flag the kinds of truly difficult questions. And what are my motives? My motives are, first of all, and right on the surface, there are people who say that we really shouldn't refer to any cases of other countries. So I want to say that argument is much less relevant than you think. The real cases are the ones I'm talking about. That's what's in front of us, and there isn't much disagreement there. It's a necessity, but I want to say an added thing, because I want to bring them along. Now, say it isn't just, I understand what you're worried about. You're worried about, will we, if we refer too much to what goes on abroad or to the decisions of foreign courts, undermine our basic American values, which are in that document, the Constitution. Values such as democracy, human rights, rule of law, broad areas for trade. And what I'm trying to show you, that person who's objecting, in this book, is that given the world as it is, The best way to preserve our American values is to participate. Take part. Find out what goes on elsewhere. Write your decisions in light of what goes on elsewhere, in part where that's relevant. And you will reach better solutions. Solutions that help to preserve American values and work better for Americans and others. And then my motive behind the motive, I think, is to say that's important for us to do. Because we're trying to prove something, or at least take a step towards proving something, and that is we can help to ameliorate, if not totally resolve, the problems that will face all of you more than they'll face me, because they're going to continue, and show the rule of law or a rule produced through fair methods can in fact help with those problems. And then the motive underlying the motive is when Sandra O'Connor and I went to India. When we went to India, we were there on the day of 9/11. And emotionally, we saw what was happening on the television. And the Indians were wonderful. The judges there, very sympathetic, said we figured out ways of continuing without having dinners and so forth, continuing our work. And the lawyers were wonderfully helpful, and judges were, and everyone we met, sympathetic. And I came away with an emotional reaction that the important differences in the world are really not between different geographical areas or races or religions or nationalities, but rather between those who believe, as a basic way of living and resolving human problems, in a rule of law, and those who don't, who think of more violent or other ways of solving problems. And we know which side we're on. But it's an important thing to prove, even to some of the others, that this rule of law and this system, complicated though it is, of laws and rules and administrative efforts and even treaties and agreements and so forth, that it can help solve these problems, that it can help, that it isn't hopeless, that it isn't just I give up, let's try it, etc. And I can't prove that either. But I hope someone reading this and getting some knowledge of how we on the Supreme Court are faced with problems thrown up by the world, very concrete ones. How we are facing challenges are important, may possibly be solved, or at least ameliorated, and that will help with what we believe in, the rule of law. Thank you. Good. I have no idea how long that took. 30 minutes?
So it's a great honor and privilege to be here commenting on Justice Breyer's book. And even before he wrote this book, I don't know if he knows this, but he had a great influence on my own view of the world. I now, as you heard when Russell introduced me, the title of my endowed chair contains the word international law in the title, and I teach international law as well as constitutional law. When I graduated from Harvard Law School, though, in the 1990s, I didn't even take a class in international law. And the classes that I had in the rest of the law school curriculum mentioned international issues, not much, if at all. I think in constitutional law, we might have spent a day or two on war powers. But other than that, I would say in my 3 years of law school, I had very little exposure to international and comparative law. And it was during first my clerkship on the Court of Appeals and then with Justice Breyer that I actually developed an interest in international law. One of the cases, or set of cases that he talks about in the book that he didn't mention in the remarks today, but are quite an interesting set of cases, involved disputes between the United States and the governments of other countries that went to the International Court of Justice when the governments of those other countries, including Mexico and Germany, were complaining that we had been arresting their citizens here in the United States for very serious crimes, murder in all of these cases, had not been informing of them of their rights under a treaty called the Vienna Convention on Consular Relations when arrested to contact their embassy or consulate. And because of that failure to notify them that they had the right to contact their embassy when arrested, those governments claimed that they had not received the adequate assistance of counsel they otherwise would have, and were on death row in the United States because of it. And so some of those cases came before the court, the term I was clerking for Justice Breyer, and it was in part because of the interest that I developed in those cases and in many conversations in which the justice was interested in learning about comparative law. How do other countries do things, whether looking at the amicus briefs or in having us conduct research, that I began to realize this is really important and is going to be of utmost importance in coming years. And so it was because of that I developed an interest in the field, and the year after I clerked for Justice Breyer, went to The Hague to clerk for a different international court, the International Criminal Tribunal for the former Yugoslavia, one of the thousands of international entities he talked about. But this brings me to two things that I want to talk about that relate to the task that Justice Breyer has set in this book of conveying to a broader audience the importance of things transnational to the world today in the legal realm. One is legal education, and why it was that when I went to Harvard Law School in the 1990s, international law seemed peripheral at best to the curriculum, and how that's changing in law schools today. And second, the task of convincing the broader public that this is a consideration of how things occur legally beyond our borders is necessary and important for American public interest for precisely the reasons Justice Breyer suggested in promoting the rule of law, in promoting the values that this country is based on around the world, when there is a very serious strand in American politics of fear of foreign and international law. And I'll talk about some of the reasons for that, and then some of the difficulties in countering some of those concerns. So let me talk first about the trends in American culture towards globalization, and then towards maybe some reluctance to engage with international and comparative law. So there's no doubt, as the Justice began by talking about, that it is an era of globalization in terms of business, media, commerce, the way people live their lives. Just one statistic with respect to Americans, I think, shows that. In 1974, only 3% of Americans had passports, and today some 46% of Americans have passports, which is an all-time high. It's still lower than many other countries. 60% of Canadians, 75% of UK citizens have them. But it shows a real change in just a generation in the percentage of Americans who expect that as part of their ordinary lives and their personal lives with their families and their business lives, that they will travel outside our borders. More than 68 million Americans traveled abroad in 2014, half just to Canada or Mexico, but others around the globe. So while there are these strong trends that are apparent to average Americans, there are also some contrary trends, and the Justice alluded to this into the arguments about the use of foreign comparative and international law in judicial decision-making. Some of the sharpest debates about that in the context of constitutional interpretation and the degree to which, for example, in death penalty cases, interpreting the Eighth Amendment's ban on cruel and unusual punishment, whether it's appropriate for justices to consider what other countries do. But aside from those debates, which preceded a fairly sophisticated level among judges in terms of when and where it's appropriate to use international law, there are other popular debates. Justice Scalia, for example, who has debated Justice Breyer on the appropriateness of the use of comparative law in constitutional interpretation, has in many other contexts suggested that it is relevant to look at comparative law. For example, Justice Scalia has written in opinions that when interpreting a multilateral treaty that was designed by the political branches to foster cooperation among nations and setting a standard, that demands looking at how other parties to that treaty have developed it. But in the more general sphere, there has been a sort of less nuanced debate about the use of foreign and comparative law. And in the last 5 years, some 32 states have introduced and debated bills that would ban judges in those states from using or looking at foreign and international law. So bans of this sort were enacted either by referendum or by state legislatures in Oklahoma, Kansas, Louisiana, Tennessee, and Arizona. One example, an Oklahoma statute was one of the first ones, was stimulated by concern about Sharia law. The Oklahoma statute provided the courts shall not look to the legal precepts of other nations or cultures. Specifically, the court shall not consider international law or Sharia law, an odd lumping together of two very different areas or lineages of law. Oklahoma's law was struck down by courts on Establishment Clause grounds, but this led to a more generic language in statutes that were proposed in other states. So, for example, a rule in Kansas provided that the courts of that state that should not look to decisions that were based in whole or in part on any foreign law, legal code, or system that wouldn't exactly track American rights and duties. And Alabama in 2014 passed a constitutional amendment that prohibited state judges in that state from, quote, application of any law, rule, or legal code system used outside of the United States. The breadth of these laws, which have yet to be fully litigated or enforced, would create a number of practical problems in a very wide array of cases. Justice Breyer's book, of course, focuses on decisions in the U.S. Supreme Court, which involve a wide range of issues. But of course, most litigation in the United States happens in state courts, and state courts are forced to consider the laws of other countries in a very wide array of cases. Commercial contract disputes, as business has become more global, in many commercial cases, the parties will be located in different countries. Family law cases, there are many situations in which ordinary, boring choice of law rules would point to the application of the law of a foreign jurisdiction. Some of these state statutes encompass not only foreign law, which creates problems in ordinary choice of law context, but also international law, which creates problems under the Supremacy Clause of the U.S. Constitution, which provides that the treaties of the United States are supreme law and should be applied by state courts. So these statutes and the broader trends they reflect present, I think, a real problem in terms of education, of understanding the ways in which international and comparative law are relevant. And one of the things I think that's a little challenge in terms of public education is that one of the sort of central way to show that international and comparative law is not necessarily threatening when used in the vast majority of cases is to show how boring those cases are, which creates a problem because if you're trying to convince people that it's really boring, it's hard to hold their attention. And so it's not just the Guantanamo cases, the death penalty cases that these sources of law are relevant to, but antitrust cases, copyright, securities law, child custody, discovery in ordinary civil litigation, a wide array of things that to the average member of the public who's not a lawyer may not seem interesting, but that show just how interwoven into the fabric of the law foreign and international law is today. And so that's a problem in terms of public education. And I think it's not without cost internationally that this strand of isolationism has developed in certain parts of the U.S. system. One of the things that Justice Breyer talked compellingly about was the importance of in the U.S. engaging with the world on rule of law issues to promote rule of law around the world. And a number of scholars, and Dean Choudhry has written a lot about transmission of constitutional values, so I won't talk about that, but have talked about in various ways about perhaps the declining influence of the U.S. Constitution and of the U.S. Supreme Court compared to some other courts around the world, like the European Court of Human Rights or the Canadian courts, for example, that might be more engaged globally and that might be perceived by other countries as more likely to engage with them in a dialogue rather than a one-way conversation. And so I think it's extremely important to think about how we can address that. So there's a question of public education, of how to respond to what I think are misguided efforts to restrict the use of comparative and international law when our judges think it's appropriate, when it is relevant to the legal issues before them, of course, not to be controlled by it, but when it becomes relevant to look to those sources. On the question of legal education, I think it is also a challenge. One of the things that Justice Breyer talks about in the book that I think is extremely important is the degree to which it's difficult for judges to master or to be equipped to look at all of the types of foreign laws that will come before them. And I think that very much that's a challenge for those of us who are law professors or law school deans in legal education to think about how to do better than Harvard did for me in the 1990s in preparing lawyers to go out and be practitioners, eventually to be judges in a global legal system, a global economy. And that includes not just offering classes in international law, but integrating that throughout law school curriculums to prepare tomorrow's lawyers for the type of practice that they will engage in. So that a class on antitrust law, of course, talks about European competition law, because that's going to be relevant for most of the people who are practicing in that field. A class in copyright and IP would talk about international and comparative examples of those fields. But that's a real challenge because developing that comparative expertise takes quite a bit of time and energy. And I think that's a real challenge that's facing legal education in the coming years. But I hope that with progress on that and thinking of how to convince the public that international law is actually quite boring most of the time and not scary. Those are some of the challenges that I think Justice Breyer's book makes great inroads in bringing to public attention right now. So thank you.
So it's a distinct honor and privilege to welcome Justice Breyer to Berkeley, and it's even more of an honor to be able to be a law professor for at least a couple of hours and comment on his really wonderful book. And like Professor Martinez, I had the pleasure of getting an advanced copy and was able to have a look at it. And what I want to do is talk about a couple of the arguments that he touched upon in the book that he also talked about today. So there's a lot of examples in the book. It's a very, very rich book that covers a lot of areas of substantive law, but there are two key ideas at the heart of the book. There's two key words, and the words are foreign and interdependence. Foreign and interdependence, and how they're related to each other is what really energizes the book. And so the basic argument of the book, as illustrated through many, many examples, is that the foreign is of increasing relevance to the Supreme Court because of the increasing interdependence of the United States to other jurisdictions. Now, so that's a long book boiled down to a sentence, but what I want to suggest is that if you look a bit deeper, there's actually two different versions of what foreign and interdependence are that are in the book, and hence two different senses in which they are interrelated. So in the first sense, what is increasingly foreign about the Supreme Court's docket is that it brings to the court foreign persons, foreign activity, foreign commerce. And cases which have one or more foreign dimensions to them increasingly fall within the jurisdiction of American law and institutions, and increasingly generate cases that come before the federal judiciary up to and including the Supreme Court. Why is that? That's because the United States finds itself in a world that is growing ever more interdependent, a world, as he says, of instant communications and commerce and shared problems of security, the environment, health, and trade, all of which ever more pervasively link individuals without regard to national boundaries. So for Justice Breyer, this first account of the relationship between cases with a foreign element being generated by patterns of growing interdependence has a lot of implications for the American judicial mindset and American legal practice. In the most abstract terms, he says, the court will increasingly have to consider activities, both non-judicial and judicial, that take place abroad. But as his careful, very thoughtful examples of antitrust and copyright law illustrate, in order to resolve these cases, the court has to do much more than reorient itself or develop an awareness of comparative law, a literacy of comparative developments. It actually has to transform how it understands federal statutes, some of the very core material at the heart of the American legal tradition. So in what way does that happen? So the court and the world argues that the Supreme Court must marshal the intricate details of foreign law, foreign regulatory practices, and the foreign economic policies underpin both in the service of a theory of statutory interpretation that, he says, must increasingly consider foreign and domestic law together as if they constituted parts of a broadly interconnected legal web. Now, historically, federal courts consider themselves under the relatively weak but important interpretive obligation to ensure that domestic and foreign laws did not impose contradictory duties upon the same individuals. But through a series of fascinating examples, Justice Breyer demonstrates how the court has increasingly gone further and has sought interpretations of American law, of federal law, that allow it to work in harmony with related foreign laws so that they together can more effectively achieve common objectives. So there is a radical pragmatism here at the heart of this idea in a way that I think is very fitting for Justice Breyer. It's pragmatic because what motivates this interpretive orientation is a desire to ensure the effectiveness of the American regulatory state in an increasingly interconnected world. The effectiveness of the American regulatory authorities is highly dependent on coordination and cooperation with foreign counterparts, which has concrete implications for very specific legal issues that become before the federal courts every day. So there's a case that the Justice talks about in his book, which held that the Sherman Act didn't apply to foreign commerce. It's a case called EMPA Graham. And the court held this notwithstanding the fact that the activity in question, which involved the vitamin cartel, did in fact have adverse effects on the United States market. So why is this? The court held this, he argued, because permitting such actions to move forward in American courts would undermine American regulatory cooperation with foreign jurisdictions, which would in turn, in the end, undermine the effectiveness of federal law. So what Justice Breyer proposes, in essence, is to renovate older doctrines of comity by developing new bridges to historically distinct doctrines of administrative law that counsel deference to regulatory expertise. The twist is this. The twist is that the scope of deference to administrators is broadened beyond the expertise of American regulators to deference to foreign regulators with whom American authorities cooperate every day, based on the cues provided by American executive branch institutions. So one way of framing this legal innovation is to say that Justice Breyer brings administrative law into international law through the cost-cutting theme of executive deference. And I want to return to that idea of executive deference in a moment. No, but in other ways, as I said, the justice is not just pragmatic, but radical. So how is he radical? So what he says is that although there are sometimes textual anchors in federal law that permit, invite, and even counsel such an approach to the interpretation of federal statutes, what he proposes is not rooted in the contingencies of legislative drafting. Rather, it is a non-textual canon of statutory interpretation that emerges from the court's evolving understanding of the rise of networked governance in a manner to how an earlier court modernized American public law in the wake of the New Deal and the rise of federal agencies, an earlier experience that Justice Breyer discusses as well. Moreover, although the regulatory networks that motivate a new doctrine of international administrative deference are built around executive institutions, it is but a small step to imagine federal courts, including the Supreme Court, as being a node in an international network of high courts that together enforce a transnational regulatory machinery in partnership with expert agencies. And so what might be thought of as commercial law or private law, beyond the interest and expertise, I must confess, of most public law scholars, raises deep and profound constitutional questions about the roots, scope, and the very self-identity of the American legal order. Scholars of American public law will find the answers to these questions in very unfamiliar places, that they ignore at their peril. In the jurisprudence of investor-state disputes arising under bilateral investment treaties, in the theory and practice of international commercial arbitration, and in the law of international trade. So now let me turn to the second account of the relationship between the foreign and interdependence in Justice Breyer's book. Now, over the past decade and a half, as Professor Martinez noted, the energy in the debate over the use of foreign law in the Supreme Court has turned on its use in constitutional interpretation. And this has been a polarizing debate that tracks very familiar ideological divisions in the court. It's been located largely in the death penalty cases, but also in the jurisprudence on same-sex rights. And Justice Kennedy and Justice Breyer have been participants in this debate on and off the bench. And it is a sterile and deadlocked debate, and I was so relieved that Justice Breyer hardly talked about it in his book, because it's really a dead debate. There's nothing interesting to say anymore. But what is important is not the debate itself, but the way in which we understand why the debate was important. The debate is important because it says that what is at stake in it is the importance of foreign ideas and intellectual interdependence between jurisdictions. So the Supreme Court is increasingly part of a global community of high courts that face roughly comparable issues. And so the book is important because it moves forward this debate and how to imagine and understand the circumstances under which the Supreme Court or any court might want to learn something by looking at comparative experience that is not binding, but which may be, on reflection, persuasive. And what's wonderful about the book is that it shifts the preoccupation of this debate away from rights and rights interpretation to questions of constitutional structure. And so there is a very interesting chapter in the book on the treaty power. And so, as you probably know, the Constitution gives the President the power to make treaties with the advice and consent of the Senate. And through the Supremacy Clause, treaties are the supreme law of the land. And so the question is, how does one reconcile the treaty power with the vesting by Article 1 of legislative power in Congress, and of course the rights-based limits on the exercise of all public power, federal or state? And so what energizes these old questions, and these are very old questions, is the change in the contemporary character of treaty making. And so, as Justice Breyer alluded to in his lecture today, we have created hundreds and hundreds and hundreds of international organizations that engage in rulemaking in a very large number of areas. And what are these areas? Environmental law, financial services and banking, cyber governance, energy, intellectual property, labor law, counterterrorism, navigation, sports, the IOC. And in addition to well-known, better-known areas such as human rights and international trade. And these organizations are highly institutionalized. They exercise law-making functions, law interpretation functions, even law enforcement functions, historically associated only with nation states. And so one of the great constitutional questions for this country in the 21st century will be how the American constitutional order comes to terms with the thickening reality of global law. The initial signs are not promising. Now, America has one of the oldest and most continuous constitutional traditions in the world, and it introduced many innovations into constitutional design, such as written constitutionalism, federalism, and combining judicial review and constitutional supremacy to yield judicial supremacy. But in the handful of early cases where the court has had some initial encounters with the rise of global law, regrettably, I think it's not adopted a particularly sophisticated or nuanced approach to these issues. And so in part, this is because of the nature of the issues that have come before the court. So Professor Martinez talked about these Vienna Convention cases that had to do with the right to consular assistance of foreign nationals arrested by American state authorities. And so what drove the controversy over those cases is that the International Court of Justice had determined that essentially what's something called the procedural default rule, a core area of federal criminal procedure in the United States, basically as applied by American courts, breached international law. And that's the heart of a couple of major judgments in Legrand and Avena. And so in American courts and before the Supreme Court in Sanchez-Lamas and Medellin, the issue came up of whether, in fact, the U.S. Supreme Court ought to defer to the ICJ's finding on this question of international law. And it's a long and complicated story, but the answer is no. The answer is no. Now, Justice Breyer dissented in both cases, but what is admirable about his book is that he doesn't re-argue the case. It's actually quite fascinating. What he does instead is to say that the way we think about the treaty power is out of date. It's not yet reached the substantive issues of legislative delegation and rights protection that are really at the heart of genuine good faith misgivings about the rise of international regulatory authority. And so one of the great strengths of this book is that it's an olive branch. It takes those concerns seriously, and it disentangles them from the kind of toxic politics that has often surrounded them. And it does so by directing American readers to the extensive experience of European constitutional courts in addressing these issues. So what is this experience, right? So for over 40 years, every major constitutional court in Europe has wrestled with what is, in essence, the flip side of what I call the merger of international and administrative law in the context of the European Union. In short, deference to international regulatory cooperation mediated by national executives, the Europeans have said is subject to limits, is subject to constitutional boundaries. And they've developed these limits in a broad variety of cases: counterterrorism cases, data privacy cases, arrest warrant cases, cases on quantitative easing by the European Central Bank. And there's a very complex set of responses that these courts have developed to how to understand the scope of international regulatory authority. So on the issue of rights, some European courts have asserted the power to review the decisions of international organizations for compliance with domestic constitutional bills of rights, okay? Others have said, well, if the international organization has a schedule of rights that is comparable or roughly similar to what we would find nationally, that's good enough for us, we'll defer. But if it's not there, we won't. That's what the Germans did, okay? A third approach has been for these domestic courts to interpret the enabling treaties that create these international organizations and to examine whether they've acted in excess of their authority. That's what the German Constitutional Court has also been doing lately as well. And so the point here is not that American courts should follow one of these recipes. They aren't recipes, okay? They're ideas. And so the benefit of intellectual engagement with these types of ideas is to learn from them, to help us to think about what to do, to help imagine how American courts might think about the evolution of American constitutional doctrine as they wrestle with the same issues. And so comparative law is a tool for stimulus and for self-reflection. And so let me conclude on this note, and it's a note where I'm in violent agreement with Associate Dean Martinez. I hope that the court and the world provokes a very important and overdue conversation in the American Legal Academy. Every legal scholar should read this book because it makes the case clearly and compellingly that international comparative and transnational law is increasingly central to the fabric of American legal practice, and it is here to stay. The court and the world is a call to arms for legal educators to reflect deeply on how American law schools should equip our students to adapt and thrive in this rapidly changing world. Thank you. Okay, so we have some time for question and answer. So what we're going to do is we're all going to be here. We're all mic'd up, and there's 2 mics in the aisle. So what I'd ask you to do, if you have a question for the justice or for anyone up here, but most likely the justice, is to come up to a mic, please. Wait till I recognize you. Introduce yourself, the year that you're in, and then state your question. And please, no speeches, just questions. Okay? Nobody? Come on.
Cold call
This
on
is,
you?
come on. This is Berkeley, guys. Come on, let's, okay. Okay.
Justice Breyer.
Sir, can you introduce yourself, please?
My name is Chris Yandel, and I'm a 2L.
Great.
So the Obergefell decision is based on the Due Process Clause of the 14th Amendment. Obergefell was a Due Process Clause case. Do you have reservations about that instead of being a kind of a more doctrinally apparent Equal Protection Clause decision, which I think most of us were hoping for?
There are one set of cases I won't discuss, which are things right in front of us. A second set of cases I won't discuss is something like the gay rights case, which is highly sensitive, even though we decided it. Therefore, I have to say, you have to read the opinion and make up your own mind. And that is basically what law students and law professors do in any event.
Great, thank you.
Justice Breyer, my name is Hassan Ahmed. I'm an LLM student originally from Canada. I wanted to ask you specifically about Guantanamo Bay, and I guess while this question might be out of the scope of the judiciary, you spoke about Guantanamo Bay and the cases that came before the Supreme Court. There was a recent New York Times op-ed talking about how Guantanamo Bay is essentially an abomination to the due process that the U.S. followed for much of its history. My question to you is more as a private citizen. How would you see the closing or the process to close down Guantanamo Bay and to transfer the detainees, whether it be in U.S. federal prisons or otherwise overseas?
As a private citizen, everyone in the United States can express his opinion, with one exception, judges who are likely to get this kind of question in front of them. It's important to keep in mind that at the time we wrote the cases, there were about 500 prisoners in Guantanamo. I gather probably the same article you read, that there are now about 160 or so at about 140?
114.
114, and about half of them the government's trying to release. And so then maybe there are about 60, and of those 60, a large number they want to put on trial, and so now we're in about 40. And what are they going to do with those 40? And I know that when we decided the cases that we decided, we said that they were prisoners of war at a time a hot war was going on in Afghanistan. And now maybe conditions have changed. Maybe the cases in light of the changed conditions will come back. I don't know. So therefore, I exercise my right as a non-private citizen not to make further comment.
Maybe some of the private citizens on the panel could answer.
You have to. Good point.
I knew I should have gone down.
I have views, but you're not here to hear my views. You're here to hear his. So I'll let others ask questions.
Do we have any more questions for the justice? Good. All right. Yes.
Hi, Justice. It's a great honor. My name is Jacob Canner. I'm a 1L. Your discussion made me think a lot about the EU and the kind of the way that all these different countries have come together in a system that's like, very integrated, that as it hasn't been, hadn't been before the 50 years prior. One response to that has been a really nasty nationalist movement in the European Union that a lot of people think is due to the integration between the countries. Your discussion, I think, was very compelling, but one thing that I was thinking was, what would be the national response? Would there, be a potential, if the courts were to be much more deferential, and maybe that's the wrong way of putting it, but much more sympathetic to international doctrines and statutory interpretations, then will there be a response from the citizens that's, not exactly what we're looking for?
It depends on how it's put. What I think was terrific for me, and it's a real privilege, was to hear the two responses. And I'm so glad that there will be a publication with those two responses. And Jennings will, in fact, say to people, look, this is the kind of stuff that's going on politically. Please look at what is really going on, which is what I hope I've exposed in the Supreme Court. Now, are these responses appropriate? And she has chapter and verse. And I suspect most people, if they read it, will say, no, that's not appropriate. If you put it in terms, is this an American Constitution that we are expounding, or a European Constitution? You know, the answer to that question isn't very tough. And if they have the impression that what the courts are doing is the latter instead of the former, they'll be annoyed. But the reason to talk about this, one reason to talk about it in depth, is the discussion with Jenny that was had, which will at least be in print. You can't guarantee anybody will read it. And as to the deans, my goodness, that was very, very nuanced. And it's hard to follow it, as it is hard to follow what I say in an audience this size. But he's right. But he's not right. Yes, yes, no, yes, no. He started talking about the nodes of integrating the foreign law into American law. No, yes. But the antitrust case is a case in which for 30 years, countries all over the world complained about a case of the Ninth Circuit, which I thought was as good a case as they could. They were doing their best. It was called Tamberlane. And it was the rules as to how you decide whether or not American antitrust law does or doesn't apply to something that happens overseas but has an effect in the United States. Is it like somebody standing offshore and throwing rocks at us? Or is it more complicated than that? And Congress finally said, this is impossible. They passed a statute. We're interpreting that statute. You read it. But they're doing their best statutorily. And they're giving us the job of interpreting that statute in a way that worked best when we took into account not just what the European authorities say, but the Justice Department told us, pay attention to what they say. You see, now, once I've told you that, which is there if you went into it in detail, you're beginning to think, this isn't such a big deal. You're just following what DOJ says and they agree. And it's a statute that's ambiguous. And now you shake your head, right. Is it a big deal? Are these things a big deal? Yeah, I think they are actually. And I think he's put his finger on some of the reasons. But very incrementally, very slowly, think about these things if people in the academic world and law students and the others read this, including the comments, and began to have a lot of different opinions about what was happening and what was being done and what should be done. I did end up by saying this is like might be like the pre-New Deal court being faced with administrative agencies. What in God's name were those? Constitution doesn't say anything about them. Crowell v. Benson. We can figure out a way of integrating them. Did it work? 80%? 80%. Slowly we come along. I can't prevent myself from saying, yeah, Jenny talks about Medellin. She worked on Medellin. Did you work on Medellin? Poor thing. I mean, my clerks looked up every case involving the interpretation of treaties as to whether they become internal law from John Marshall onward. And we concluded the best advice on this was given by John Marshall. If it's a political matter, it doesn't become automatically internal law. If it's not a political matter and a minor matter addressed to judges, it looks like it does. All right, that was okay, that's what we said. And boy, they worked hard to prove that, but how far did we get? I don't know. In fact, I think you're absolutely right when you say the European Court of Justice did not fully understand the concept of procedural default. Well, why should they? This is a curly-Q, unbelievable, complicated thing. Sometimes it works well, sometimes it works terribly. In the American criminal law, growing out of the fact that we have 50 states, and they are supposed to interpret that when they're, my God, it's a miracle they got it as right as they did. And yet, you say, I want people to, so what? So we shouldn't follow it? I mean, how wrong do they have to be? Okay? In other words, very nuanced questions, very difficult, but when you see the whole field, it's Fabrice Del Dongo on the field of Waterloo. Something big is happening here, and I'm not just sure what it was, or is. And therefore we have the book and the discussion, and that just couldn't delight me more. Thank you.
Hello, Justice Breyer. Thank you for your comments. I'm an LLM student. I studied and practiced law in India. My question is, when we look at comparative law, what difference in approach do we take between judicial and non-judicial actions of foreign governments?
It depends on the case. I mean, if it is a judicial action interpreting a domestic relations treaty, every single member of our court will take that as having not, if not binding effect, at least worth close consideration. What someone in a legislature happens to say in a statute, I haven't seen that, but I doubt it's worth the same consideration, because what they're not trying to do is interpret some words in a treaty. If it's some other thing, it might be less consideration. See, so it depends.
Hi, my name is Eliza Dugan. I'm a third year. Justice Breyer, thank you so much for coming. As you were speaking, you were alluding to the Hague Convention and some domestic relations and how that relates to international law. And we like to speak a lot about intersectionality here at Berkeley. And so I was hoping that maybe you could comment on how American values of racial justice and gender justice also intersect with these international treaties and international law.
They're mostly in treaties, too. We're not the only country to think of this, you know. Right. And they're in a lot of treaties. And they're in a lot of foreign rules. And they haven't... You wanted an example that's sort of almost not really very relevant, but was moving to me on the field. I put it in the book. And I think it's something that's a benefit that we can do now. We can talk to people via Skype. And so the State Department sets these things up sometimes. So it set up an afternoon where I spoke via Skype to a law school audience in Tunisia, in Tunis. And there were students, and there were some professors, and there were some people who were working on the Constitution. And after a while, you know, with a law school audience, or any audience, you can begin to get frank discussion going if you make an effort. And after a while, a young woman came up and she said, well, in your Constitution, you protect religion. Well, what happens if it's a sort of fundamentalist religion? And how do you deal with that? And I wasn't quite sure what she was driving at. But after a while, the light struck. And I said, oh, you're worried that the new Constitution will have something in it that stops you from going to law school. And she said, exactly. And some other women came up who were in the class, and they said, we are too. And I said, well, I'd like to think of something to help you. I can tell you, I'm with you. I certainly hope they don't. My wife works on the organization, International Center for Research on Women. And so I've learned something from that. And in my own view, as in many, a lot of these problems, making certain that women get educated and so forth, it's almost trite. Can help in a lot of areas. They want a lot better life for their own children and so forth and so on. So I have a chance to say something that will encourage her. I can't pass a law. I can't even tell them what to do. I have to say what you do over there is your business. You have to decide. We can tell you things about our country and what we know, but we cannot really direct what is best for Tunisia. But in the conversation, having such a conversation in such a class, I have an emotional feeling that it might help, even if only a tiny small bit. And that's simply another way. I think that judges or others who have the opportunity to talk to their counterparts in other countries about questions that might make a difference to them can help. And that's another way in which the world intrudes in our lives.
Thank you.
So this is the last question.
Hi, my name is Lydia Anderson-Dana. I'm a 3L. This follows a bit on Eliza's question, but I was wondering if you could speak to, when researching this book or just generally assessing the validity of other courts' decisions, how you grapple with, or maybe don't grapple with, cultural relativism.
I don't know. It didn't seem, the research is really, and I thank you for this, because together, I think it was together, Yale, and probably you too, paid for some students to do research on the book. I couldn't have done it otherwise. And they were very good student researchers. And we were trying to look into specific problems, as you'll see. So the question of, I can't think of the cultural relativism coming up. It may be there somewhere, but I just can't think of it coming up.
So we'll make this the last question. Yep.
Hello, my name is Tomasz Koncewicz. I'm the Fulbright visiting professor at the Berkeley Law School. I used to clerk for British judge on the ECJ, and I was the referender of the Polish judge on the ECJ.
Who is the
Judge Edward.
Oh, he's great. He was from Scotland.
And yes, I took my law degree from the University of Edinburgh, so he was my professor there as well. I have two short questions. What is your take on the so-called dialogue between the judges? And secondly, what is your understanding of the relevance and importance of the foreign courts' case law in the practice of the USA Supreme Court?
I'm not sure I'm following.
So the use of foreign law in the U.S. Supreme Court, and the first question was on digital dialogue.
Well, we do. I mean, foreign judges do come sometimes, and sometimes we go over there. And I just came back 3 weeks ago from a discussion with 3 British judges, Reed, Mance, and Mary Arden. And we had Justice Ginsburg, Justice Alito, and me, and some lawyers. And they set it up in advance, and they had materials on privacy, on federalism, and on legal education, and the cost of bringing cases. And it wasn't just what we do. We had a good discussion. I thought the discussions were pretty good. You say, does that turn into concrete results? I don't know. I don't know. A conversation, the best thing, and I put it in as a kind of bookmark here, is Michael Oakeshott. He said a conversation is something where there is no winner, there is no loser. People are not trying to outdo the other. They're not trying to produce the best argument. They're listening to each other. The value of it is not who makes the better argument or who wins. The value of it is the remnants of the conversation that remain in the minds of the participants after they finish. That's called education, in part, and that's something I learned 2 weeks ago. And as to the direct relevance of their cases, it depends on the case. And we refer to it sometimes. I put the best examples I could think of showing the point in the book. And towards the end, I wrote some of the things I'd learned about proportionality, because proportionality is a term they use in First Amendment cases and many other cases, which I think is virtually identical to what we call balancing. And balancing judges hate. They can't stand it, because they say, balance what? I mean, that calls for subjective judgment, it seems, and that's what you don't want. But sometimes you have to have it. And they've worked out that balancing, so it's somewhat, if you follow the way in which they do it, it's more transparent, I think sometimes produces a better decision. All right, so there are examples, and that's others I've used. But I found most of these discussions pretty valuable.
Thank you.
So I'd like to conclude this part of the proceedings by thanking all of you for joining us this year at the Jorde Symposium. Special thanks to Justice Breyer and his chambers for accepting our invitation to speak this year. Thanks to Judge Charles Breyer, a loyal grad of the school, Professor Russell Robinson, Professor Jenny Martinez for joining us and participating in today's program. We'd also like to thank the Brennan Center at NYU and the Event Services Unit at Berkeley for organizing this program this year, the Blum Center for developing economies for co-sponsoring this year's event, the California Law Review for annually publishing the symposium, the digital clerks of the late Justice Brennan who are in attendance today, and of course the benefactor and namesake of today's symposium, Emeritus Professor at Berkeley, Tom Jorde. Because this is a symposium about a book, we have books for sale, and there'll be a sale. And moreover, Justice Breyer will be signing books for a few minutes after the reception, if you happen to have brought a copy with you. And so we're having a small reception here just outside the hall to the right once you exit the room. Thank you again, and we look forward to seeing you next year.